go ahead and get started. Welcome everyone, good afternoon, and thanks for taking the time today to come to our webinar on family matters. I'm super excited to make some quick introductions here before we get started on our presentation today. Just a little bit about ASAP before we get started. I'm Diana Murray. I'm the CEO of ASAP Accounting and Payroll. We provide payroll processing to lots of clients in the region, mainly in Colorado, as well in 42 different states. I've got an awesome team that does this for our employers, and really our aim is to be a resource. And that's why we're here today. We want to provide this resource and educate you all on things that impact your workforce and impact your business. So thanks for taking time today to connect with ASAP and to connect on this topic. I'm super excited to introduce Michael Santo as our speaker and presenter today on this topic. And before I kind of turn it over to Michael, I would like to also mention that we are hosting an in-person employment law seminar in Glenwood Springs on Thursday, November 17th, where we'll cover this topic as well as other topics. So if you are interested in attending this in-person event, please let us know or stay tuned on our newsletter for the registration details, but go ahead and mark that on your calendar, and we'll look forward to having people attend that as well. But for today, we are talking just about family and not all the legislative changes that are coming about. And so just want to talk for a minute here on what we're going to cover today with Michael. Really, we're focused on family and calculating and deducting employee premiums. And that really starts on January 1st. So this is coming up fast, and we're going to talk about the updates, how it'll work, how this impacts our employers, and especially those that have multi-state or have remote workers in Colorado. You might be on the call today as well. There is an exemption process that we'll talk about, as well as just the impacts here on what this means for your employment policies. So we're going to cover a lot of information in a short amount of time. Michael's already overwhelmed. And so with that, thank you, Michael, for being here. And I'm very excited to get started on this topic today. So I'm going to go ahead and let you share from here.
Sound.
And actually, but as you're sharing your screen, Michael, in terms of, I don't have my notes in front of me, so I'm going off the fly, but I will mention some technical details as it relates to Zoom and how we will operate this webinar. So we have a lot of information to cover. Michael has a lot of information to share with us today. So I will ask you to use the Q&A feature of the Zoom controls to ask any question throughout today's webinar. Tracy on ASAP's team and myself, Diana, will be moderating, and we'll try to answer questions or share what might be coming up in future slides as we go. I will interrupt Michael if I feel it's necessary at that moment. Otherwise, we'll try and save questions for as we maybe pause through to different topics related to the program. So go ahead and use that Q&A feature. If you are having any technical problems, you can go ahead and use the chat, but otherwise, please use the Q&A feature for asking questions. All righty, thanks so much. Take it away, Michael.
Certainly, and as I told Diana before the talk, if anyone after, I will do what I can. We were joking, there's a lot of materials to cover. We did this talk recently in Durango, and at that talk we had 90 minutes. So this talk we have 60, so we're gonna go hit some highlights. If you have questions that don't get answered, please feel free to call, reach out. Please feel free to reach out to Diana. You can certainly email me if you don't get a question. Just if you're going to email me, which is just santo@bechtelsanto.com, kind of just combine it all. Just let me know ASAP talk, because then I'll say, great, I'll just answer a question or two about family, whatever we didn't get to. So please let me know. We are here to cover family, but I would be remiss in not mentioning a couple of things that I want to make sure is on everyone's radar. One, if you haven't changed your workers' comp poster yet, haven't changed your workers' comp information, you are a little bit behind. It had to be changed mid-August. Employees now have 10 days to report. There's a new poster. Make sure you get the poster up. It has to be 40 by 27 when it's printed out. So make sure that new poster is up. It's available on the Colorado Department of Labor's site. They did a very nice job of getting it up. But the problem is it can be difficult to print off in 40 by 27, but that is the requirement. So make sure you get that changed and your policies are changed accordingly. One big thing. Two big thing, we are probably no more than 2 to 3 weeks away from President Biden's administration announcing that we're going to see a change to the salary basis test. That is when you determine whether or not you have to owe or pay someone overtime. In Colorado, we are currently at, you have to have a salary of at least $45,000. The United States government has one in the mid-30s, which doesn't matter for us because we're at 45. On January 1st of next year, 2023, we go up to 50,000. There is a rumor out there that the administration, the federal administration, may go as high as 80, 85,000, 75,000. So they may go flying past us, which is going to change how we all create or how we classify exempt employees. Make sure you're keeping track of that coming up. Enough on that. Oh, and then if you have any non-compete agreements with your employees, you definitely want to make sure you're reaching out to counsel because that just changed in August, a very massive change. So let's talk about FAMLI. The number one question I get on FAMLI, besides what does it stand for, is what about that court case? Is that court case going to go? Is there anything because of COVID that's going away? No, it's happening. The court case, the Supreme Court dismissed the case. The case had been brought that this was a tax, and the court ruled it is not a tax. One more big thing coming up. This is mentioned with FAMLI. President Biden announced 2 weeks ago that we are no longer COVID's no longer a public health emergency. That did not change our requirements under Colorado's public health emergency law. That is as designated by the Department of Health. Theirs is set to expire mid-October. So make sure you're looking to see whether or not HIFWA, public health emergency, goes away. I wanted to bring a couple things, and that was the third thing. So we are still under a public health emergency, according to the Department of Health, through at least mid-October. Okay, court case. Court case is over. We have FAMLI. What is FAMLI? Well, as the slides are identified here, FAMLI will provide Colorado workers with 12 to 16 weeks of paid leave. What are the reasons? This is going to track a lot, pretty much along the lines of the Family Medical Leave Act, with one addition, which is the fifth bullet point there. But it's going to manage their own serious health condition, the employee's own serious health condition. Number two, to care for family members with a serious health condition. Family, that's the way we tend to refer to the state law as family. To distinguish, I try to refer to the Family Medical Leave Act under federal law is FMLA or FMLA. That law had the same requirement to care for a family member with a serious health condition, but they had a very narrow definition of family member. Theirs was spouse, child, parents. That's it. Colorado's family has a much more expansive one. So employees are going to be able to take off leave for a lot of different individuals than they were under FMLA. For example, if one of the things that was in the regulations is if the individual identifies a person on their emergency contact in their information submitted with you, that's probably going to be someone they can take off leave for under family. Another thing that's similar to the FMLA under family is to care for a new child, to make arrangements for military deployment. Both of those are covered. So all those are covered. And then to address immediate safety needs and impact of domestic violence, sexual harassment issues, or assault issues. Those are not covered under FMLA, although they may be covered under FMLA for another reason, but they are specifically set out in family. So that's what individuals are going to be able to take 12 to 16 weeks of leave for. Unlike FMLA, and this is by far the biggest change, is Colorado Family will be paid. We'll get to how much in a second. FMLA is definitely not paid. The 16 weeks, by the way, up there is for pregnancy. So if they are for pregnancy in that third bullet, or you may be looking at 16 weeks of leave instead of just 12. Where are we? Well, we're in this little diagram here, which was helpfully provided by the Colorado Department of Labor and Employment. I have, by the way, as a side point, I frequently, let's just say I don't always agree with the Colorado Department of Labor, but if there's one place I really agree with how well they're doing, they are getting out information like crazy on family and also in their new interpretive notices. I constantly encourage organizations when I do talks, make sure you have the department's interpretive notice page bookmarked. Make sure you have family bookmarked. They are sending out so much information now. It's almost a little much, but I really appreciate them providing it because they're constantly letting us know new regulations. Sometimes I wish they'd slow down because I just learned the last ones when they come out with new ones, but this is on their site and it really does a nice job of outlining where we are. We are, of course, just after July 22. Public education campaign began. They're everywhere. They're doing an amazing job getting out and speaking to the community. I can't encourage, if you see one in your town, or you can get on a Zoom, try to show up. I always joke, I probably am a little more aggressive in my advice because I'm guessing ahead where they're more restricted to what's already out there. But they also do a really nice job in listening to what folks say and incorporating it into future potential regulations. So always show up, ask questions. If you've got complaints, bring them up. And I've always found that group to be very good to listen to. What happens January 1, 2023? Well, one of the things that I think is missing from the department slide here is we as employers between coming up, but it's definitely before January 1, we all need to register on the family site. If you're opting out, if you're a government employer, if you're going to a private one, if you have a different group or whatever, you still need to sign up on the site. Someone asked a question, well, is it available now? That's an excellent question. And I really wish I had looked at that before, just a few minutes before the talk. I don't think it's up yet, but I think mainly because I think if it was, they'd do a very good job of letting us all know. But you want to make sure before January 1, 2023, sometime in November, sometime in December, that you are definitely getting on the site, whether you're opting out or not, or whether or not you're going to use a private plan or not. Make sure that you're submitting your company's information. They need that no matter what. How do I move? There we go. I'm going to move this so because I don't need to see me. I know what I look like. Whoops. Let me go back. Then you're going to start collecting premiums from the employee. You're going to pay those premiums come. There we go. You're going to start paying those premiums to the department April 30th, 2023. There has been some information. They got the private plan information really quickly recently, but there have been some talk that if they didn't get certain plans approved prior to January 1st or even prior to April 30th, that they would collect premiums if you were going to use a separate plan and then in essence pay back those premiums when you transfer over to the separate plan. The leave though doesn't begin to 2024. Does that mean as an organization that, well, we don't have anything to do till then with our employees? No, I'd start getting out information. I'd really start getting out information because I think people will be a little surprised to suddenly see a little bit of money coming out of their check. It's not very much, but it's going to come out. And they may say, hey, what's this other deduction here? So start getting information out to your employees on how that's going to work, what it's going to be, maybe even giving them the family poster so they can see what they can start using in 2024. But that is out there. What are the responsibilities for premiums? Well, as the department did here, those with 9 or fewer employees, the responsibilities for the premiums are the employees. Let me go back to here. The premiums are currently set at 0.9% of his wages, with the employer paying 0.45 and the employee paying the other half. Employers, of course, can pay the full thing. When you see the employee premium there, you may say, well, does that mean the employee has to pay the full thing? The employee's responsible for their share. 10 plus employees, you're responsible for your premium as well. So you have to pay the 0.45. Then you get the rest of the participating self-employed have to pay for their own. If you're an employee of a local government that's opted out, you've got to pay your own. Non-participating, they're not required to submit any premiums. They can, as we I think it's ahead, but maybe not, but just to cover one of the issues Diana talked about. As a local government, there was some confusion caused with the requirement as to when that had to happen. It went around that it had to happen in June and July. It does not. You still have time to conduct that vote. And then when you would, what you're voting on is, are we going to not participate at all? Are we going to have a partial participation where we're not going to participate for money, but we will be responsible for submitting the premiums? Or are we participating in full? So it's a vote that has to happen coming up. It's a vote that you're going to have to identify when you sign up your organization. So those are certainly coming up soon. We get asked all the time, well, this is going up, right? Right now, we are set at the 0.9 premium rate through 2024. That is fixed. Thereafter, the director will set the premium rate according to the formula as identified there. But the way the law is written is that it is capped at 1.2%. Is it possible we can find a way around that and change laws? I certainly, anything's possible. But right now, the way the law reads is that we are capped at 0.1 or 1.2%, and that would then be equally shared. So we've got the premium starting in 2023, and then we've got the leave starting in 2024. Do you have to have a leave policy out right away? You don't have to, but I would certainly start laying the groundwork with your employees as to how that leave is going to work. One of the main questions we get is, well, hold on, what kind of leave is what of the wages are subject to the premiums? Because it's not just as simple as wages. All these amounts, I get asked all the time, how are we going to figure out tips? And I said, that is an interesting question. But each of these wages are identified as being subject to the premiums. So make sure that will be something coming up. What is not included in wages is really important, which is the per diem, the mileage reimbursement, into any other insurance not associated with family. For example, short-term disability, long-term disability, medical hospitalizations, sickness or accident, death, earnings, investments, severance pay, those kinds of things. One of the things that I think is interesting, I'm just going to throw out there for consideration. I don't have an answer to it, but I will, something to consider as particularly those organizations that are paying that are 10 or more employees. Is that short or long-term disability? If you currently have short or long-term disability, a lot of organizations are telling me, well, employees don't use it very much. It's not, it's not particularly well used. And I wonder why that is, particularly because there's some concern that employees will use a lot of family, where we already have short or long-term disability. One of the reasons I was wondering for that difference would be the issue of that employees here are contributing to the payment. Employees are actually seeing a withdrawal from their check to pay for family, where they may not be seeing that for short or long-term disability policies. So it's certainly something to consider. I just throwing it out there for consideration, whether or not an organization pays the entire amount. And would that then, not discourage, but would that then, does an employee paying encourage their use more than if the employer paid the whole thing? I don't know the answer to that question. I'm not a psychologist, just an attorney, but it would be an interesting kind of study to see how different usage is with family than what you've seen as an organization with short or long-term disability. Employers will carry the burden of making sure we're doing this correctly. So that is a big requirement. Okay. Sorry, I apologize. My family is down in Tampa, Sarasota area. And so I was actually giving a talk yesterday and I told participants, I may be getting text. And if that happens, I'm going to look to see if it's my parents because I want to make sure they're okay. They are okay, and things are good today for them. So, but I just still, if you see me checking, that's why. If we make a mistake, there's discussions that we will cover it for the pay period. We cannot go back later and deduct the amount from the employee's paycheck. So keep in mind that if we make a mistake, and it is something where it benefits the employee, we may, the way it's currently reads is we're not going to be able to go back and deduct. So that will be something to consider. Taking a big breath to see if Diana wants to throw in a quick question. One of the questions we always get is, well, hold on, how do we calculate the number of employees? I'm like right at 9, I'm right at 12. I got some who are interns. I got some who are coming and going. The department, where they can, and I think this has been something they really, I don't know, but at least in my review of the information that are coming out, when they can use information from the Family and Medical Leave Act, when they can use regulations, seems like they're going to use those. One of the places it looks like they're using those, certainly, is the FMLA on the number of employees, which is your count will be calculated, as it says, once a year. Total number of employees equals the number of employees on the payroll during each 20 or more work weeks in the preceding calendar year. So, for example, if you've got 11, and then the next week you have 8, well, right now you only got 1 week. But it doesn't need to be consecutive. It needs to be 20 or more calendar work weeks. So you'll need to figure out how many times, if you're on that threshold, how many times did we have 11? Did we have 9? That's going to be your calculation. And or do we have 10? If you have 10 or more for 20 or more weeks in all of 2022, we are you're going to be on the hook for sharing in the premiums or paying the share of the premiums. A lot of people will say, well, I got an employee on workers' comp leave, even though there's not technically a workers' comp leave. Let's just say employees on leave. Do I count them? Yeah. If the employee is expected to return, like if they're missing time for workers' compensation injuries, or if they're trekking Nepal on a 3-month hike, and they're expected to come back, that employee would be considered as part of the work weeks. So it's really just those that appear on your payroll more than it's those you're paying. So if you've got people who you're like, well, God, Bob and Alice, they haven't worked in ages. They're like temporary. They're like PRN. They barely come in. Still, if they're on that payroll, they're going to count. This is a really good slide, I thought, put together by the Department of Labor. Did a really nice job, and that's gave them credit in the lower left-hand corner there. And this is in the information they present in their talks. But if an employee is has a weekly wage of $500, they're going to see a $2.25 deduction. Their weekly benefit would then be $450, maximum benefit of $5,400, which would give them 90% of what their normal earnings are. You can see how the chart goes along, and then eventually when you hit that 2,000 cap, or the $2,000 weekly wage, that is where the weekly benefit caps out at that $1,100. And you can see that as you make more, your percentage of weekly wage gets a little smaller. So this is when you have employees and you're wondering, well, what's my employee's benefit going to be for these type of leaves when they're out? That is the breakdown there for 2024, as an example by the DOL. What is it going to look like? Well, it's going to look like this check. You can see that the family premium is identified. You can see the 4 things above it are called a tax. This is not a tax. The Supreme Court says it's not a tax. I know that may get a few chuckles from folks saying it looks like a tax, but it's not. It's definitely not a tax. You can ask the Colorado Supreme Court. It is not a tax. So we've been identifying as family premium. And that is, for example, maybe how the check will look. You can see where the deductions, which ones are not subject to the premiums, all that issue. So that is an example of how the check. So how is this all going to work? Diana, questions or keep going?
There's a couple questions real quick that I want to that I think kind of go in line with what you're talking about. Does this take the place of, if somebody qualifies for FMLA, does this run side by side? Does it take the place of it? How does that work side by side?
It's a great question. If you're covered by both FMLA and FAMLI, you can run those concurrently. It's not 24 weeks of leave, it's 12 weeks of leave in full, or 16 if you're for pregnancy. One of the questions that someone submitted said, well, hold on a second. That doesn't quite work, because under FAMLI, we can use PTO, HFLA, and a whole bunch of other things when they're out on leave. And you can't do that under FAMLI, Colorado FAMLI. Well, you can't do it, but you can do it with the employee's permission. Under the FMLA, under FMLA, you are permitted as an organization, when someone's out on FMLA leave, to tell them, look, while you're out in this leave, you're also going to use your PTO benefits. You're going to use your vacation. You're going to use your HFLA. You're going to use whatever leave we may have, paid leave, you're going to use at the same time. Under FAMLI, you can't do that. But what you can do is you can provide employees the opportunity to make up the difference of that offset. So you can see how an employee with a weekly wage of $500 there gets a weekly benefit of $450. So they're losing-ish $50. You can say to the employee, hey, you want to burn your PTO to cover that offset? If the employee says, yeah, I don't want to do that, then you're stuck with that answer. If the employee says, yeah, I'm not going to be able to make mortgage, I'm not going to be able to make my rent unless I get a full paycheck, then yes, you can do that. But unlike FMLA, where we can force it, Colorado FAMLI, we have to get the employee's permission. Was that the couple, or was that all?
I think the rest we can answer towards the end.
Okay. The end.
Right? Or at a time. Some of these I think you might touch on. So
just joking. All good, Diana. Okay, what do we got here? So, whoa. So we're going to contribute employees, and they're getting, Department of Labor is coming in as, they're really, I think at this stage, really focusing more on the payments than they necessarily are how the leave is going to work, but they are getting more and more information out. And then once 2024 happens, the employees will apply for benefits. Employers initially, and I think this harkens back to something I said earlier, basically employers had very little, if any, involvement in it. And there was no period, or there was no procedure for an organization to come in and say, whoa, 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 we think Bob's providing you false information. The employee could submit an appeal, but the initial ones didn't talk much about, or if any, about the employer submitting an appeal. That's changing. Now they're talking about, if you have a good faith belief, there are going to be appeal rights, but those will obviously be developed more and more as we get closer to 2024. So what's the division going to do? Well, they're going to evaluate claims. They're going to request documentation. And then from there, they're going to approve or deny benefits. Unlike FMLA, unlike HIFRA, we are not required to do anything to make the determination. The department will handle, the division, sorry, I always say department, but it's division. The division will handle that approval or denial of benefits. Come on, go. Who's eligible? And I think people are a little shocked to find out any Colorado worker who makes more than $2,500 in yearly wages with the state, they are eligible. So one of the questions I got was from someone who said, well, what happens if we got temporary employees and then they go off to another part of the state and work over there for a while? Well, if they earn $2,500 in their base period and they're not with you anymore, they're going to be able to take the leave at their new organization. Similarly, as you bring in employees and they've had $2,500 in the base period going back, they're going to be eligible to take that leave. They have to be with you for 6 months before they get reinstatement rights, but they will be able to take leave right from the beginning if they meet that yearly wages of $2,500. Even if you're exempt, you got employees who can use it. If you're a sole proprietor, you can opt into it as well. Oh, here we go. It's already here. Employees who have served at their job for 180 or more days cannot be penalized and terminated. We all understand that. But really, they're going to be able to request FMLA, use FMLA. That's for those who, for reinstatement rights and those kind of issues. The job protection, they borrowed this in large part from the FMLA, which is they have to come back to the same or equivalent position. They must retain any and all accrued seniority benefits. One of the things that's interesting is that one in the lower left-hand corner, the one that says employers may not count FMLA balances as an absence. I was meeting with an organization a couple of months ago about leaves and those kind of things. And an attendee asked, I thought, a great question. When I went over part of this, they said, well, I'm confused. If I've got an employee, Alice and Bob, and Alice uses FMLA or uses FAMLI as it's coming up, and they use the full 12 weeks. And I got Bob, who hasn't taken a day off during his entire employment. So when I decide who I'm going to promote, Alice just took off 12 weeks. I mean, she hasn't been available. Bob, he's been here. And I said, well, I jokingly told her, we're going to have to work on your deposition testimony. But the real key is that Alice's leave, she did not miss. She has perfect attendance, even though she may have taken off 12 weeks in her FMLA, 12 weeks in her family. She still has perfect attendance. So a reason cannot be, well, Bob's here, Alice isn't, because taking leave under FMLA or taking leave under FAMLI is not, this can be a double negative, but is not being at work. That employee does not have any attendance issues who has taken 12 weeks under FAMLI. So you still have to look at, she's going to be, Alice is going to be just equal with Bob when we decide who we're going to promote or maybe who we're going to lay off or those kind of things. So be very careful on that. I get asked all the time, I really don't want to do this, and the employees really don't want to do it. Well, we got to find those 60% of the people then who voted for it and talk to them, because 60% of people in Colorado did vote for this. So it's happening. It's a large percentage. And And for the exemption, there's only 3. And that's those who are local government, those who are self-employed, and those with the private insured. But they still need to take proactive steps, even if they cover. We've already gone over this with the local government entities. You have 3 options, have to be voted on by the board, needs to be, obviously, I'm not a county attorney per se, but when you're getting out information about the meeting where this is going to happen, it's not one of those things you want to sneak in the back door. You want to make sure employees are aware what they're going to be voting on, send a letter to employees so they know that the board is going to be addressing this issue. And so everybody's on the same page. Who is a local government? Well, these are the groups that are covered and are allowed to exempt themselves. Where is it? In 3 years. Oh, that it's also, that's an interesting statement. I don't know why I put it in there that way, but even if you opt out, you still have to register. Employees must participate or may participate and receive job protection when applicable. Local government, they have to vote, they have to notify, and they have to notice. So and the notice one is within 30 days after the first one, the vote. You've got to notice employees. You have to notify the division prior to January 1, 2023. Again, for local governments, there was that issue that maybe it was June or July. Not. The department makes very clear on that on their site. If you vote for no participation as a government for those government employers that we have out there, you do not participate, not required to take steps to remit employee premiums. Employees who opt in, they'll register with the FAMLI Division. They're going to calculate their own premium. They're going to remit their portion of the premiums independently. I think it was in the most recent one, but I got a lot of papers in front of me that they have to agree to submit, they have to agree to participate for a minimum of 3 years. So it's not as though your employees can come to you and say, hey, I just started doing FAMLI and I want to take it off next week. And then when I'm done with it, I'm going to drop out. Not going to work that way. They have to agree to stay in. If you opt out, they're not going to be entitled to job protection or benefit protection while on leave, unless, of course, your insurance policy requires it. Middle of the road option, this is one where the employer, you don't contribute, but instead the employer takes on the burden of calculating, remitting premiums to the division. In essence, it's going to work a lot like unemployment. And then you got the no, which is that there's no participation. And so look at that. This is a very good slide put out by the Department of Labor with respect to the timeline of when you have to notify. Similar to employees, you have to require length of participation is 3 years. If you opt in after opting out, also you have to affirmatively vote every 8 years. Keep that on the time frame. As I've jokingly said, I'll be retired by then after I take my family leave. No, I'm kidding. Where would I go and have this much fun? Private plans are allowed. Be very careful with the private plan. I've had organizations say, well, we're just going to cover this all ourselves. And I said, great. What's the usage rate going to be? And they said, well, I don't know. And I said, well, that will be hard to figure out. If you don't know the usage rate, you may be into a lot bigger burden than you realize. So make sure you're not just thinking, well, no one's going to use it, it'll be fine, because you have to provide all the same benefits. You've got to give the same level of wage replacement. You've got to make sure you're deducting no more than the same amount and to cover all employees through the duration. The private plan, I did say, was prepared just a little bit ago, that they're still writing detailed regulations. They just came out with those recently. I think it's section 7. And they go into, where is that? Nope, not that one. Here it is. Specifically, as compared to the public family program, the private plan provides the same number of weeks, provides the same level of wage replacement, no additional requirement or condition, so you can't change things like you have to submit documents within blah, 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 or blah, blah, blah. Can't do that. It's got to cover all employees during the duration of their employment. This means that new employees, part-time employees, or temporary employees must be eligible so long as they have earned $2,500 in the state of Colorado. They must remain compliant with all other family requirements. And here's a big one. Be approved by the state as compliant. The state admitted in a recent one that they've got a lot of people requesting. So make sure you get those approved. It's not just something you do. If you're self-employed, you are not required to participate in family, although you certainly can. You're going to be responsible for 0.45%. And if you do that, you can withdraw for the next 3 years. So self-employed individuals are also going to be able to participate. Really, pretty much everyone in the state's going to be able to participate. For FMLA covered entities, it's going to be rare that if they're covered by FMLA, that they're not going to be covered by family. You may be covered by family, but not be covered by FMLA, because family is much broader in terms of who you can take the leave off for, and it has additional things. As I say here, they run concurrently, and so they're also covered by. They're also covered by FMLA. Sorry, I looked at the bottom one as I was looking ahead. It says if an employee takes family, they're not also entitled to 12 weeks of FMLA. I probably could have written that better. They're entitled to 12 weeks of FMLA, but it happens at the same time with family. I meant to say they don't get to take it after. The biggest issue is, or I think not the biggest, but one of the issues out there, don't forget, just like FMLA, that employees are going to be able to use this as intermittently. It isn't just 12 weeks of leave. It can be increments as small as an hour, which is a little different than FMLA. I've actually seen organizations do FMLA by the 10th of an hour, but man, I wouldn't do it that way, but that seems like a lot of work. But the employee will not be paid by the division on those increments until they have used 8 hours of the paid leave. So keep in mind that it's not just 12 weeks of leave. If I'm getting treatment on my knee, for example, and I need Thursday afternoons off, that's going to be covered by family and FMLA if I'm at an organization large enough to be covered by the FMLA. You can use something like, I forget the exact number, but it's around 9 hours a week of intermittent leave an employee can and never, ever run out of leave. Because the leave is 480 hours every rolling year. It's not just 12 weeks like we're dealing with public health emergency now under Fmla. This is 12 weeks every year. We've talked about all this, and it kind of goes over the HIFLA thing too. FMLA cannot be used to cover an employer's obligations under few. Few may go away in November. Be anxious to see what the Federal Department of Health does with that. What information do employers receive when employee requests? Because this is where I think I'm anxious to see some regulations come out with the Department of Labor on this, that they will let the employee know, but it's an odd timing issue, because if the employee submits a notice or submits a request to the division to use family, and then the division comes back and says, no, you can't take it to go to Barbados just because you really, really want to go to Barbados. Now that employee may have missed because maybe they've gone to Barbados before they got the approval. So that situation will be an employee goes out on leave, and as an employer, we've almost conditionally approved it. But then when the employee doesn't get approval, that now turns into unapproved leave. May also get some fraud issues from the division as well. But the division is not getting a lot of information, or not planning. The current plan is not to give a lot of information to employers. Initially, it was almost none unless the employer approved. Now, in recent publication I saw, they're looking a little more. What do you do if you're multi-state? And there's a question at the end of this. Employers, and there's maybe a better Q&A at the end, but employers who work or live in Colorado for out-of-state entities may be covered by FAMLI. Multi-state organizations must count all employees in all states for premium purposes. So if you've got, 10 employees in 6 different states, you're going to be covered, even though perhaps some of those employees may not be covered. We're going to get to that Q&A, so don't hold on to that question for those of you who have multi-state analysis. And here we have a slide here that is before the Q&A. What are we looking at in terms of which employees, the wage analysis? Their entire service is performed in Colorado. If it's both within and outside of Colorado, but the services are incidental to the employee's work in Colorado, that's going to be part of the wage withholding. And then you've got the and options as well there. You have to meet these requirements to determine if an employee is eligible. Oh, we've already talked about this a little bit, so I jumped ahead a little bit. May an employer require an employee to exhaust accrued PTO before taking FAMLI? So in essence, can it go first? Can you say you have to use PTO, then FAMLI? No. FAMLI, in essence, trumps PTO. We've talked about this, that it can cover the gap. Are employers responsible for paying leave? Because employers and the division in their materials, and particularly some of their Q&As, employers who express concern like, what am I going to do? Where am I going to get all these employees from to replace the employees who are now on leave? And then in the division's Q&A, they identify, don't forget, folks, you're not paying those people who are now out. So you now have those wages to find a replacement worker. Seem to be a frequent theme of their Q&As is what they say is the cost savings realized by the organization, because while the employee's out, we're not paying anything unless they're using their PTO or HIFWA or some kind of leave to supplement the gap. We are still responsible for paying the share premiums. And we are still required to keep the employee on our health insurance during the FAMLI, just like you are under FMLA. So I just want to see where I am. How am I doing? I'm doing good. How often can an employee take FAMLI? Well, they can take up to 12 weeks, 16 for pregnancy, for qualified events, for rolling years. So what you're going to do, for example, if we're in 2025, and obviously in 2024, it won't be an issue because they won't have used any. But in 2025, let's say they come to you on July 1st, 2025. You would look back to July 1st, 2024. We have the third example there. March 1, 2024. They cannot be eligible if they use all 12 weeks until March 1, 2025. Really March 2, I think. That's bad math there on my part. March 2, 2025 until leave drops off on the end side. So we're always looking when the employee requests, you just go back a year. Has the employee used 12 or the 16 weeks during the last year? If the answer is yes, they can't use any more leave. If they haven't, and what we say in the bottom bullet here is they may use it intermittently, so you're always looking back 1 week they use 9, 1 week they use 30, then they use 10, then they use 40. Keeping track of those 480 hours over the past year will be so critical in these things. And of course, the department has done a nice job of identifying if anyone's found to have willfully made a false statement, submitted a false document, they will be very unhappy. I would not want the state of Colorado unhappy with me. What do we got here? So they came out with new regulations in August of 2022. At the end, they received, as you see here, they received 300 written and oral comments. And there were some notable changes that came from those comments. So again, if you've got questions, if you've got concerns, if you've got questions, certainly reach out to us, reach out to Diana's group. If you've got, hey, this isn't provided for in the rules, reach out to the division because they made some notable changes in their new regulations, and they're updating them as they go along. The deadline for submitting an application when the need for leave is for unforeseeable. When it's foreseeable, they're supposed to submit it, obviously when it's foreseeable. But if it's unforeseeable, initially that had been identified as to you couldn't ask for the leave, or you could ask for family within 7 days of going out on leave. That's been changed to 30 days after the leave has begun. So they extended the deadline to submit a request for family benefits. I think taking into account employees may not know when they go out on leave that they're even really eligible for family benefits. And so they've given employees a little bit more time. We talked about this earlier. Initial appeal rights really were limited to the employee's ability to complain about that. That's true. But employers now have the ability to complain. They'll also have the ability to get limited information regarding the amount and the reasons for leave. Initially, they basically said no unless the employee agrees, but now due to benefit coordination, they're allowing that. When they finished those, they began working on the private plan rules. As I identified, those are, must be in 5, not 7. Those are already just came out. So if you've got questions on those, make sure you take a look at those. Division, I thought there's some questions and answers that they had in their materials. One of those is, what do I do when an employee is on leave? I thought this was an interesting one. They were again identified. Look, you're not required to pay wages for them. They almost put I think they did try to put a little positive spin, and they called it vacancy savings. To which I remember thinking when I read that, or vacancy lack of performance, because all of a sudden now we don't have an employee there. That I hear that all the time, and I know I've spoken to the division about this. They're aware, and they're not immune to this as well. Where a lot of people focus on the payment of leave and where's the benefits and those kind of things. I think the biggest thing Colorado employers are going to have to work through with family is where we're going to get the workers. That remains an issue within Colorado. We are currently in the throes of the Great Resignation, and we do not have a ton of workers just lining up to work. But what they identify as vacancy savings may give organizations the ability to contract with temporary workers to supplement current staffing needs. So yes, we've got that already. I have a highly skilled worker and a temporary worker would not be a solution for our company, is one of the Q&As, and the department was cognizant of it, basically saying, yeah, we understand it may put a burden on you, but they hope that then with the vacancy savings that they're able, maybe with bonuses, bonuses or hazard pay for other employees to take on additional work, bring in temporary labor, that those savings may allow organizations to cover for highly skilled workers. How do I count nationwide employees? As we already talked about, your total nationwide employee count will be what determines whether or not you pay the employer's share. So if you've got, 2 or 6 in 5 states, so you got 30, you're covered. Keep in mind that you're going to be, excuse me, covered with the nationwide. Couple of quick interesting issues with respect to those who have worked inside Colorado, outside Colorado. Are these employees subject to FAMLI? An employee who works outside of Colorado, but the company is in. An employee who works inside of Colorado, but lives in another state. Under the FAMLI Act, most private sectors must provide FAMLI to their Colorado employees, whether through the state-run plan or their own plan. An employee's wages will be subject to FAMLI premiums if, and we've talked about this before, the employee's work is performed within the state, they perform work both inside and outside the state, and these issues as well, which we've already covered. So that's the issue with out-of-state workers. I thought it was a great question from the Colorado Department of Labor and Employment on their website as to how to address that issue. Key takeaway, I'd say, while Diana tees up some questions and I look back at my notes, is make sure you sign up. Make sure you sign up early as you can. Sign up. Get on there, whether you anticipate opting out or not. Make sure you're identifying your organization. Make sure you're getting set up. We've all, for example, I don't know how they kept up during the time, but Colorado Unemployment Division, certainly with COVID after the fraud filings, just had a huge amount. At the same time, they were trying to take on a conversion to the portal. It's a lot going on all at once. So, I always say, the old joke about voting in Chicago was always vote early and often. I would jokingly say sign up early and often. It's never too early to sign up to make sure you're covered. I think a line I'll be using is please avoid the Christmas rush and sign up before Christmas as opposed to waiting until December 31st when everyone's popping champagne corks. What a wonderful thing to do on December 31st.
I was going to say champagne corks and FAMLI. I'm not sure they go together, but okay, I'm going to go.
My joke remains, Diana, as you and I have talked about, I know you heard me say, I hear from people all the time saying, I'm going to retire before this goes into effect. And I will continue to remind people that is so short-sighted to retire before 2024. Stay until 2024, take the 12 weeks, then retire. Come on, folks, you're going to pay into it. So.
All righty, let's see. I like your joke is I really hope you're not going to retire before this because we all need you. There's so many questions that have come in. So I'll do my best to try and group some together. Some I feel like we've answered as we've moved along, but I'm going to actually move back to the top. And there was some questions regarding self-employment. So like what qualifies as a non-participating self-employment?
I think when they're self-employment, I'd look at, for example, would be those independent contractors who you have, you're your only employee. You run a landscaping company, but you are your only employee. You run a construction stucco company. You're the only employee-ish. You're an owner. That would be the self-employment that we're looking at. There's a lot of small businesses out there in essence.
And let's see here. So for bonuses that are partially paid based on hours worked, we can't reduce due to the hours worked. We can't reduce it due to FAMLI. Is that correct?
Right. There's the law, the case law under FMLA is kind of weird. It kind of goes back and forth, quite honestly, in terms of whether or not you're allowed to give a perfect attendance bonus or not. whether you're allowed to not give a perfect attendance bonus to someone who's out on family. I've seen cases go back ways, but at least under family, Colorado family, no dings based upon usage. It's just you don't want to ding them at all. It is like they're there.
Okay. If a company elects to provide a private plan equivalent to family and run that private plan concurrent with FMLA, can the company require the employee to use accrued leave in addition to family leave? Although I'm confused with the family, because if they're doing a private plan, then it's not family. So just wrap your head around that.
It would be, so what I think I get the question is, you got someone who's got 50 or more employees, so they're covered by FMLA. Now we're going to be covered by family, but we're going to use a private plan that's going to pay for family. We're not going to go through the state. We're going to sign up still. Sign up. This is me signing up. And we're going to, but we're going to handle the whole thing either internally as a company, self-insured, or we're going to use a separate private plan. And now that we've done that, hey, we're not under family, because so now we can require them to be concurrent usage. No, because your private plan, think of family as a floor, not a ceiling. And so I like Zoom because I get to do that visual. So it's you got the floor, which is that you can't use PTO when they're out on family. So to use PTO would be under the floor. Now we're in the basement. Sorry, I'm back in the Midwest. We don't have any basements in Grand Junction, but let's say we did. We're now in the basement. You could make it another way, but to now go, that would be contrary to family. So you really want to make sure your benefits, all the terms offered under family under a private plan, equal the same or better terms provide under Colorado state family.
Makes sense.
I think what the person was thinking is, hey, since I'm not under Colorado family and I'm under FMLA, and FMLA permits PTO usage concurrently, that gives me the ability. I don't read it that way. I read it that you would still, because you have to, it's got to walk like a duck and quack like a duck and look like a duck to be approved by the division. And if your private self-funded, maybe family policy is different and requires PTO usage, I could see the division say, we can't approve that because that's not as good as what we're offering.
Makes sense. Are H-2A workers, are they exempt from paying the premium?
I wouldn't think so, but you've officially stumped me. Send out a newsletter. I keep a piece of paper handy because when I do family, I always get stumped on a couple of things, and it gives us the ability to send out a newsletter. We will send out a newsletter, and Diana, I know your group gets it, so
yeah,
workers covered by family, and we'll send it out in the next little bit as to whether or not H-2A. I would assume everyone's covered because then they get to use it, but that's off the top of my head. There is no basis for that. It's just me guessing.
I know if we had a notepad or a highlighter to throw.
CDLE, Tracy would have the definitive, or either yes or no. If she knew, or if she didn't, she would say, nope, we haven't decided that yet. So right. I'm like, I don't know, I'm going to guess. She's smarter and doesn't guess about things.
Okay, let's see. Do you have any advice for multi-state employers for any issues that might arise when an out-of-state employee who might be under similar circumstances, example, not holding a position even though you're required to hold a position for a Colorado employee under family? Is this going to cause liability issues for treating employees differently?
Liability, if you're following the law, the answer would be no. But, hurt feelings, employees not feeling like they're being, they're treated as, hey, I don't matter because I'm not in Colorado. That is something. I work with organizations who have employees in Washington, have employees in California. They even some that have employees in Rhode Island. Talk to them. They've already started giving their employees that same leave, simply because they didn't want to create hey, I want to go to California just so I can get the leave. I want to go here just so I can get the leave. So I don't see liability when you're complying with the law, but I do see certainly some concerns from employees saying, I guess I don't matter because I'm not in Colorado.
Yeah. Can you talk a little bit about owners or partners? If they're on payroll, if they're not on payroll, are they eligible for those benefits? Can they opt out?
If they're an employee of their own organization, like I'm an employee of Bechtel and Santo, we're too small to be covered. But if we were covered, I would be part of that group. There's no opting out. Employees can't say, nope, I don't want it. If you're a covered entity, you're in. All your employees are in.
Mm-hmm. And if you're an owner on payroll, you're in.
You're in.
Yeah. Let's see here.
Don't only give me the easy ones.
I know. Well, they're asking as I'm going, so it's my head is spinning.
There are no easy under family. I give the division as hard a time as anybody about certain things. We don't always agree, but there's so much to get up to speed by January 1st, and we've got to get the premium issue figured out.
Yep.
That's paramount. So I appreciate them saying in so many words, we're getting the premium things out. We get another 6 to 9 months a year on how to figure out the rest of it. We'll give you the parameters, but they're doing a nice job because the appeal has already been figured out. They heard from employers saying, hey, you're not giving us enough information. So they're starting to give us more information on these things. So definitely they're listening to employers. So your voice is not quieted over there. Make sure you're speaking it if you've got concerns.
When an employee is out on family leave, is the employer still paying family premiums?
I mean, if they're on intermittent, yes, because you're still taking the wages. You're still making that premium payment. If they're on full, I think you would certainly make the premium payment to the extent that they were working, and then you would have their premium payment, the 50% on top of that. Payments. So from the employer, there's a 30-day delay on I think there's a 30-day grace period on the first one, but there's so you're going to get employees with some amount of wages during that, I guess, unless they're on 16 weeks of pregnancy. It's an interesting question.
Yeah. So let's see, we have a couple questions regarding to bonuses. So are premiums paid on regular bonuses? So on that bonus compensation?
Are premiums paid by the division?
I read that. I'm not really sure.
The division's got their salary amount, and then if we go back to the chart, they're paying the percentage of that to the employee. If you've got an attendance bonus, well, those bonuses would be included in their regular rate, which could certainly, I guess, kick up folks' wages. That's certainly a possibility.
Right, and that would be, the second question related to that is, are bonuses included in the total wage to determine the premiums? But that might be on the division.
Yeah, that would initially be, I'm trying to find the one we had. What's the next one, Diana, while I'm looking?
We have, I'm going to shift back to out-of-state employees.
No. Sorry, go ahead. Yeah. Payments defined. So in our 6th slide, going back to the bonuses, FMLA wages subject to payment would be payments defined as wages under FUTA. Well, that would definitely should cover those bonuses.
Okay. Let's see. For employers that have 9 or fewer employees, does the employee contribute the full 0.9% or only 0.45?
0.45.
Yep. Um,
I hope so, because that's what I'm planning to contribute.
on the out-of-state employees, so if the employer is in Colorado, but we have employees that are out of state, this does not apply to them, correct?
Right. That's what, do you go to that? Where is it? It's in one of the later slides there.
Right. And then on the flip,
you count them to determine if you're over your threshold.
Good point. That's a good point. And then on the flip side of that, if you have employees like crossing state lines doing work, say in New Mexico or Utah and Colorado, yes, they would be eligible, correct?
Right. If you look at slide 42 of our materials, we talk about, is it performed entirely in Colorado? Does it work both in Colorado and outside, but the work outside is incidental? And then going over to 43, you got those 2 criteria there. The employee's base of operations is in Colorado, or if there's no base, the work is directed or controlled in Colorado, or neither the base or of operations nor the place from which some or part of the work is directed or controlled. Those are your criteria that you're looking for out of state.
Okay. And then can the employee use PTO benefits to cover the premium amounts?
Yeah, they can to cover the shortage. If it's up to them, they can use those. I know some organizations that are talking about reshifting their short-term disability, long-term disability, maybe not offering that, instead providing employees almost like a bank to pull from for the gap. So because they're going to take the savings from not providing short-term or long-term disability, and they're thinking of then switching it over to provide gap wages for those two is a consideration.
Is there, in terms of the job protection when employees come back after family, is there a time frame when employers are not allowed to terminate for performance-related reasons, for example?
It's a great question. So employee comes back, they've been on leave for 12 weeks, they've been on leave for 16 weeks, and all of a sudden they come back. Retaliation claims, I say, are in essence calendar claims. So for example, I go out from January 1 to March 31st, I come back on April 2nd or April 1st, and you say, hey, remember that thing you did in December? Well, we're firing you for it. Okay, that seems a little odd because I was just out for 3 months and nothing seemed to be a problem. Now, if I did that in event, or if I did that conduct, engage in that conduct, seconds before I went on FMLA, seconds before I went on family, maybe you didn't want to bring it up while I was on family. That makes some sense. But if I come back on April 2nd and I'm late, and you say, God, you were late a dozen times before you went on family, that looks a little odd. On the other hand, employee comes back from family, that same provision, out from January 1 to March 31st, and the second or third day back, they punch somebody. Okay, you don't have to give them a second chance just simply because they return from family. So what you need to make sure, much like I was talking earlier about not using family as a ding, the same sense. How would you treat similar employees who weren't out on family? Someone returns from family and you're like, God, you're back your second day. You just took an extra donut. You're fired. Well, who doesn't steal an extra donut every now and again? So that's not going to be an issue. I mean, not from a donut store. I don't mean that. I mean, from like the company kitchen. But, minor things, you're not going to want to use those as big dings for termination for an employee who's just in the process of taking family, just gotten back from family. But if it's someone if it's conduct you would have terminated, whether they were on family or not on family, that is certainly something that can be a cause for termination.
Talk a little bit about the private insurance. Still seems a bit elusive in terms of, what do the employers need to do differently to comply with family? Is it my understanding that they will have to apply for that exemption through the division, and that's really at their discretion?
Yeah, they're going to have to go out and in essence find private insurance. Right. They have to find a group that meets all the requirements. I have not been involved in any of those processes yet, and as the division just identified, they've just come out with rules on how they're going to work, and they've been in the approval process. Work with carriers, work with insurance companies to see if they're offering family insurance, see if they've been approved by the division yet, or if they're in the process of getting approved. Once they are approved, then you can use that insurance as opposed to using the Colorado insurance. If your plan is to use an insurance from XYZ Inc., and XYZ Inc. hasn't gotten approval from December 31st or by April 1st when premiums are due, or April 30th, the exact date of the premiums, you would make those, the way I saw it mentioned in publication, is you would make those premiums to the state. And then if XYZ employer got, or XYZ insurance got approved down the road, you could then switch over to there. But in the interim, you got to make payments and got to do withdrawals for premiums from the employees, even if your insurance hasn't been approved yet, it's in the process of getting approved. So start working on the private insurance, start reaching out. If you're going to go a different direction, make sure you're making those processes now, not down the road. Don't wait till Christmas.
If an employee takes 40 hours of PTO in a week and then applies for family, what's the employer's responsibility? Pay the PTO.
Yeah, but I mean, yes, that's a great question. Wow. So I learned so much from doing these talks. I think it's one of the reasons I really enjoy them. When you think about that, you got an employee who goes out for PTO. Let's say they decide to go skiing in the Alps. I love coming up with examples. And the first day they break their leg. And because they're in the Alps or in Banff, British Columbia or somewhere where there's no cell coverage, and they're like, well, I couldn't apply. So my PTO covered that first week, but then I get back from Banff on my helicopter ski trip and I say, look, I broke my knee, blew out my knee first day. I don't want to use PTO. I want that to be family. Then we're going to have to reverse it. They're going to be eligible to submit a family application because they're within the 30 days. They're going to then, since we can't use PTO first, we got to use family first. So in essence, we're going to have to throw the money back, do something to get the accrual back in the PTO. It could be kind of a mess.
Yeah, it does sound messy. At the same time, though, I think that the division and the employer, if they're having to upload their last 2 check stubs, for example, like I imagine the division is going to do some scrutiny as it relates to that application process.
You would, but then you get the issue, not to debate you, but the issue where the division kind of says, hey, did you just put PTO before family?
Yeah.
And we'd be like, no, we didn't. It happened organically, and we're reversing, so it'll be interesting.
And then in terms of verbiage for handbooks, as it relates to family, is this something that you all provide? Tell me a little bit about what consult you provide employers, and can you help with handbooks, Michael?
We do. We help with frequent handbooks. I have been saying, I know the division in their information on their website talks about getting a policy on the premium withdrawal. I could not agree more that we need to get, as employers, information out to employees that we're going to start doing this. You want to make sure employees are not surprised by a premium withdrawal. So I would change the handbook to identify that. I mean, I wouldn't go crazy on it though, because like, for example, I read a lot of handbooks. I don't see a lot of information in there about FICA withdrawals. I don't see a lot of information about unemployment withdrawals. There's a lot of things now. Health insurance, that is discussed in the handbook. So I would hit the highlights of it. At this point, I would not get very procedural in terms of how it's going to work. We've got to all of 2023, and I know I've jokingly said don't avoid the Christmas rush, but this would be one of those things where I would not go too aggressive in 2022 because it may change in 2023. The division has their first one they issued. They came out with a revised one. So I would give it a few months till things kind of work through the process before you start coming up with procedures. We do that, and certainly we'll be doing a lot of that in 2023.
Good point. And Tracy did just share in the chat a document that the division put out in terms of a toolkit for employees. So be sure to check out that link, and we can include that in the post-webinar information as well. Last question, can premiums be paid monthly or quarterly? Instead of quarterly?
Oh, why would you pay them early?
I'm going to say go with what the requirements are and go quarterly.
Yeah, talk to Diana about that. I would go quarterly. I mean, Diana, do you know a lot of people who do like unemployment monthly instead of quarterly?
Well, no, because they hire us to do it for them. So
if only we knew a good payroll group that would be able to help with those issues.
If only you knew a good payroll provider. Well, with that, that's
Diana, thanks so much for the opportunity today to talk to everyone.